Hi everyone, I'm Otto, attorney at law in South Florida with the Otto Law Group. Thanks for joining us for this episode of Now You Know the Law. So you're out and about doing your grocery shopping one day, dressed to pussfoot in your Sunday best, when all of a sudden you find yourself falling on your back, your feet up in the air, hat fly off and everything. Well, when you get yourself together, you realize the floor is wet and that you slipped and fell in what seems to be a puddle of water on the floor. Dollar signs flash across your mind as you quickly realize you're in a mega store, and this could well be your time to make a rendition of When Me Win the Lotto. Now, you're hurt from the accident, and after going to the urgent care facility, you realize you're going to have to spend quite a bit for medical expenses and other expenses as a result. You decide you want to sue them, but you're not sure what you'll need to prove in order to recover for your damages. Well, here's what you need to know. This is a typical slip and fall case, and what you'll need to show, among other things, is that your accident was caused by a dangerous condition on the property, which presented an unreasonable risk of harm to those on the property, and which a reasonable person would not have anticipated. And so you're thinking, well, I'm a reasonable person, and I never anticipated it. But that's not all. You must also show that the owner knew about the dangerous condition. This is called the requirement of notice and is often where things get a little bit dicey. Now, there are a few different ways to assert that the property owner knew of the dangerous condition. The first is that the owner created the dangerous condition, him or herself. Second, the property owner actually knew of the condition and was negligent in failing to correct it. Third, you can show that the condition existed for a long enough period of time that a reasonable property owner should have discovered and corrected it before the accident occurred. Basically, you have to show that the owners should have done something about the situation and that they had sufficient notice and time to actually do something about it, but that they failed to do so. But remember, courts are reluctant to impose a duty for premises owners to have someone watching every little corner of their property every minute of the day and cleaning up every little spill immediately. So if you're walking down the aisle in the supermarket and someone dropped a cup of juice right in front of you and you happen to slip and fall into it, is it really the store owner who is at fault there? Probably not. But if the juice was on the floor for hours on end and the evidence shows that the employees either knew or should have known about it, but that they did nothing about it, that's a different story. You may be able to successfully argue that the store owner is at fault in that case and liable for your damages. If so, they'll be responsible for paying for your hospital bills, loss of wages, pain and suffering, and other losses suffered as a result of the accident. So here's the bottom line. If you've been involved in a slip or trip and fall accident and you've been otherwise injured on someone else's property, not everything is recoverable, but it sure would be against your interest not to find out. Dealing with the medical bills and the pain and suffering that come along with these types of injuries can be very overwhelming. If you're in this position or know someone who is, give our office a call and we can assess your legal rights to compensation. Thanks for joining us, and we'll see you next time. I'm Otto, and Now You Know the Law.
Now You Know the Law is brought to you by the Otto Law Group. If you have a legal question, give us a call. We'll either help you with the matter or put you in touch with someone who can. To have your questions answered in one of our episodes, you may submit them via our Facebook page at facebook.com/Otto Law Group. The Otto Law Group, providing legal solutions.